All right, well, thank you all very much for attending. My name is Scott Clements, and we're going to be welcomed today by Dave Wonkel of Iger, Wonkel, and Bonkowski, and Michael Berg of the Berg Insurance Group. We're here to represent CAI, and I know your first question is, well, what's CAI? Thank you for asking. Community Associations Institute is an international organization dedicated to the betterment of HOA living. It has 60 chapters worldwide. It has over 40,000 members. Here in California, Orange County is its largest chapter, and we have 1,500 membership. The membership is distributed between three categories. One category is homeowners. So board members, homeowners that are anticipating or part of their association's governance and management, they join so that they can get the benefits of working with professionals in the industry and the variety of information that's available. CAI has the largest library of homeowner association related material. Then there's the community management industry, people who operate community managements in conjunction with these board of directors. And then there's the business partners, people, CPAs, attorneys, contractors such as plumbing, electrical, mechanical, roofing, etc. So we all participate in this group to give the betterment to the association living aspect, because as you know, an HOA is a very unique animal. And we're going to spend a couple hours today talking about the legal aspects, the insurance, and the financial aspects that a real estate professional should be aware of when working with an HOA. And the reason that we're doing this, of course, is to help you. We understand how challenging your work can be, particularly with an HOA, which are each unique. They have their own set of CC&Rs and governance. So we want to educate you a little bit on that so that you can have the best results for your clients. Because, and I guess I should have started off with this, I'm a recovering realtor. So I understand the needs of the real estate industry and know how hard it is. So we want to help you. And we know that the best way to help you is to help you get referrals, because that's the longevity of a real estate professional. If you don't have a lot of repeat and referral business, well, then you're always scratching for new business, right? So we want to make sure to give good results to your clients and help them ask those very important questions like, what did my real estate agent do to help me? And of course, would you recommend them to a friend or relative? So we're going to go through the legal, the insurance, and the financial aspects to help you understand. And quote, we're not going to make you go and become a lawyer, an insurance professional, or a financial wizard. What we are going to do is educate you where these resources are. So we'll talk about it multiple times today. But cai.oc.org is our website. It comes up on several screens. So if you have any questions as it relates to HOAs, you can go to that website, get information. As I mentioned, we have the world's largest library, and we have a number of in-person meetings so that you can learn and understand HOAs a little bit better. So with that, I will introduce Dave Wonkel of, as I mentioned, Iger, Wonkel, and Bonkowski. It's a law firm specializing in HOA law. David, despite his youthful appearance, has been doing this for quite some time. He's an award winner for our chapter at caioc.org and specializes in HOA law, both understanding as a corporate level and a corporate account, I would say, that they provide legal counsel for associations, and as a professional litigator. He has experience in both those aspects of law and as a good source of information. So with that, I will turn it over to David.
Thank you, Scott. And thanks to everybody for attending this morning. As Scott mentioned, one of the things that we try to do here today, and as Scott mentioned, I've got about 28 years now of practice experience as an attorney. The last 15 have been dedicated exclusively to the representation of homeowners associations. And a little caveat that we lawyers have to give as part of our licensing is to let you know that although I am a lawyer and the information I provide you here today is legal information and the types of things that we would give to our clients as well, this is not legal advice, and we can't have you rely upon anything we say here. We always want you to get your own attorney when it comes to understanding how things work within associations, all the various different aspects of what you're doing with, of course, on your side as a realtor when you're representing clients for purposes of purchasing within HOAs, etc. So although I may answer questions here, and I am a lawyer, I am not your lawyer, so I'm not giving you advice on what happens. So that's a little caveat that we have to do in order to protect ourselves from, of course, anybody relying upon what we say here today in general when you use it specifically. We will like to try to answer questions as you bring them up. If you have a specific question regarding something that we're talking about, please put it in the chat, as Scott mentioned. We'll try to get to them as we go. But for the most part, we'd like to save them for towards the end and those sorts of things. Please recognize I can't answer any questions about a specific fact pattern. What I can do is answer theoretical things and the kinds of hypothetical scenarios that you might be able to raise. I'd be happy to try to give you a basic answer. But of course, the ultimate answer always from a lawyer is, it depends, and it will depend on the facts and circumstances of your particular circumstance as to what the true answer might be. So seek that out from your attorney. With that being said, I'm happy to now talk about what we deal with in HOAs. And we've put this program together from the legal side of things based upon the concept of knowing what areas we run into as association lawyers when we meet new owners within homeowners associations that don't understand what it is they purchased. Usually that training for an individual comes from the realtors. The realtor often will explain to the individual owner what they're receiving and what they're buying when they buy into a homeowners association, and maybe how that works. So this education is designed to give you an understanding so that you can better help your clients to understand what they're buying and how it works within the system that they're buying so that they get a better life experience after they've purchased their property. And of course, same thing goes for the seller side. Selling comes with a lot of disclosures, comes with a lot of understanding of what they are selling when they sell it. So those kinds of things come here too. So the first thing we want to do is we want to give you a solid understanding of the major types of properties that we have in homeowners associations. There are essentially 4 types, 2 of which you're going to run into most often. And the first one that we're going to talk about here is a condominium. Many people confuse or don't understand what a condominium is as compared to any other property. Condominium doesn't mean that it is a stacked unit or something of that nature. But what it basically means is, from a condo point of view, you're buying airspace. You're not buying structure for the most part. You may be responsible as an individual owner for the maintenance of the structure, but you don't actually own the structure yourself. You own the airspace inside a particular structure. The association as a whole, meaning all of the owners combined, own what's known as the common area. And that's usually the building, the components of the building, the grounds where the building is located, the streets perhaps, all of those sorts of things are known as common area. The building itself, the roof, the walls, the exterior portion of the building, the area of floor in between the floors of the condominiums is all common area. The airspace inside usually starts at the paint and of the perimeter walls and moves in, the paint on the ceiling and moves down, and then the slab, or on a second floor, the lightweight concrete slab in between the 2 floors up. So if you put flooring down, that's usually the individuals. If you paint the walls or put wallpaper on the walls, that's the individuals. And if you paint the ceiling, the paint is the individuals, and everything inside of that, except for certain types of things like electrical wires and plumbing, etc. So that's the kind of thing that happens within a condominium. And that's the kind of thing, usually if you see stacked units, one unit above another unit, that's almost certainly going to be a condominium because there's no land ownership associated with a condominium. So Scott, if you can move to the next slide. The other type of ownership is a planned development. Now, you might hear things like PUD, right? PUD, which planned development kind of works because there's no U in there, but planned development is what we use in California. PUD is a nationwide planned unit development. We don't use the term unit when we talk about planned developments in California. So it's a PD or a PUD, if you want to call it that way. But what that means here is you typically, as a planned development, you own the land, you own the structure, and you own the airspace within that structure when you buy a piece of property. Now, that doesn't mean that you're going to maintain everything. The CC&Rs will describe all that, and we'll get to that when we come along. But usually, the individual owns the land, owns the structure, and all of the associated complementary improvements on the land itself. And then the common area are other pieces of property, like the streets, the pool, the clubhouse, parks, whatever it is that's around there. Those will be common areas. Sometimes that's slopes. Some other types of things might be in the area where the association, instead of the community as a group, the association owns those pieces of land itself rather than the individual owners. So in a planned development versus a condominium, those are the 2 distinctions. One is the association as a group owns all of the structure and the land. That's a condominium, and the individual owns airspace. In a planned development, all of the owners individually own their own piece of property and the structure on it. So the reason being, if you see a stacked unit, that's almost always a planned development. If you see individual homes, that doesn't necessarily mean I'm sorry, say the way around. If you stacked homes, it's condominium. If you see separated homes, it's often a planned development, but not necessarily. We'll talk about that as we go. The other two types, which are less common, community apartment projects and stock cooperatives. If you do work in Laguna Woods or in Golden Rain, you are probably going to see something along the stock cooperatives, or maybe in Long Beach, there's a lot of community apartment projects from the old times. These were apartment projects that were ultimately maybe converted into associations or common interest developments, as we refer to them. And then stock cooperatives, where the corporation owns everything, and then you receive a certificate that says that you own this particular piece or share of the community, which is a unit. So those are a little bit more or a little less common than the other two. For the most part, you're going to be dealing with condominiums and planned developments. Scott, next slide. Okay. One of the issues that we almost always see is that people call me up and they say, I own a townhouse. What is that? Townhouse is not a legal term. It doesn't mean anything other than usually meaning that you have a single unit up and down, meaning there's often 2 floors to it or more, and they're often side by side connected to the sides, not necessarily connected up and down, although they can be. So townhouse doesn't tell me anything about what it is that you have purchased. Is it a condominium? Meaning that the association owns this entire structure and the individual owns the airspace? Or is it a planned development where each of those up and down units is owned by the individual, the structure as well, and they share common walls, which they share between them as far as maintenance is concerned? We can't tell. The other thing is that those types of terms, townhouse is a description of the type of construction, and it's a marketing term to tell you what it's going to look like when you get to that community. But it does not create any difference between who is responsible for maintenance or who owns what. Only the governing documents can tell you that. And again, same thing with the idea, single family attached or single family detached. Those are not legal terms. Those are just marketing to try to give you an understanding of what the community is designed as from a construction point of view. It doesn't change anything as to whether or not you're a condominium or a planned development. There are plenty of communities now, they call them canopy condos, where you have single family homes that are separated, but they're condominiums, meaning that the association as a whole owns all of the structures, but the individuals just own the airspace inside. They're just not connected in any way. And there's the opposite, as mentioned, townhomes. They are connected. They're literally connected across each other, or sometimes up to many, many units per building, but the individual owns their own structure itself all the way through. So please understand that when you do review whether or not you're selling a townhouse, it's important to understand, is that townhouse a condo? Or is that townhouse a planned development? Because you can't tell by looking at it. You've got to look at the governing documents and understand. So when we talk about governing documents are the authority that affects the association itself. But before we get there, we have to talk about the kind of laws that we're dealing with when it comes to associations and how they operate. So amongst community associations, there's common interest development law, which is what's known as the Davis-Sterling Act. And that Davis-Sterling Act is codified in Civil Code sections 4000 through the end of the 5000 series of the Davis-Sterling Act. That covers all of the various things you see on the slide here: maintenance, assessments, insurance, construction defect claims, how voting is to take place within the community, what documents are available to members upon request, what documents can be charged for by the management company and or the association if you ask for them, how meetings take place, all of the discipline associated with making sure that the rules are followed, etc., how you create rules, how you change your governing documents. All of that is codified within the Civil Code for the most part. Go to the next slide, Scotty. The second area of law that is important is the Corporations Code. The corporations code is the area of law that deals with the company that is an association. So almost all California associations are corporations. And I say almost because there are plenty of unincorporated associations that are out there, or those that are just a little older, or the kinds of things that have not been incorporated otherwise. But for the most part, the vast majority of associations in California are corporations. They are common interest, mutual benefit corporations. So they are nonprofits in the sense that they do not earn money. They bring in a budget and they spend that budget every year. So they're nonprofits, and they are mutual benefit, meaning that the corporation is designed around the idea that the benefits and responsibilities of the entirety are available to all of their members. They are membership corporations, not stock corporations. So in that, there's the corporations code affects all of those sorts of things. And of course, within associations, you still have all of these other laws that still apply, like the vehicle code. 22658 is the vehicle code section that allows associations to be able to remove vehicles from their properties, because most associations are private property. In order to remove private vehicles from private property, you have to have authority under the law to do so if it's not yours. And since associations need that authority under the law, that's where they get it from the vehicle code. And the next slide, Scott, is the health and safety code. There's also many other code sections like health and safety, or the Fair Housing Act within California. All of the sorts of things that come into play that apply to like daycare centers, or for the health and safety code, it also deals with rehab centers. When I would say rehab center, more like a sober living homes that can be done within associations, are all governed by the health and safety code for California. Let's go. Less common things that we have to deal with in common interest developments, but they are still there, are the federal laws, and there's quite a few of them that apply. For the most part, and this is something that you should understand, for the most part, homeowners associations are private entities and they are private property. The Americans with Disabilities Act, ADA, does not apply to common interest developments in California unless very specific criteria are met to make them apply. The ADA, the Americans with Disabilities Act, doesn't apply to HOAs because the Americans with Disabilities Act applies to places of public accommodation. And since these are private entities and private property, they are not open to the public. Even though you may not have gates, you may be wide open, anybody can drive through. But from a true legal aspect, only members have the rights to actually be on the property, but they have the right to bring their guests and invitees. But it's not open to the public. We don't provide public service or retail opportunities. There are some associations that do. And if they do, such as condominiums that may be on the second, third, and fourth levels that have retail at the bottom level, the ADA is going to apply to the bottom level where there is access to the public for retail services, things of that nature. But for the most part, the ADA does not apply to common interest developments. But that doesn't mean that the issues associated with the ADA don't apply at all. They often do, because California has its own laws and set of laws that sort of mirror the ADA for purposes of the housing environment, which under the federal law, it's the Federal Fair Housing Amendments Act, and California has something similar. Then there's the Bankruptcy Code, of course, and the Fair Debt Collections Practices Act, which goes along with the Bankruptcy Code in how you collect assessments in the same similar ways to that you would collect taxes, like property taxes. If they're not paid, the government can, for property taxes, if they're not paid, the government can come in and foreclose upon your home. Same thing happens with HOAs. If you have not paid your assessments on time, the HOA can come in and foreclose upon your home if you meet certain criteria again. So all of those sorts of things do apply. So there's a lot of laws that overarch the governance of community associations. But we also have the kinds of things that case law brings to us. Not only is the Davis-Sterling Act there, but we have the codified laws. We also have case law. Now, for those who aren't lawyers and probably have never paid much attention to what we do as a practice, case law is the things that the lawyers end up making after we go to a case at trial. So a certain set of facts comes up. We apply the law to those facts. We go to trial. The judge makes a ruling. That ruling then goes up the appellate level, and the appellate court says yay or nay on what the judge ultimately decided, or maybe what the jury decided in the particular case. And they describe the facts and how the law applies to it. So usually this is an interpretation issue. Case law is an interpretation of the laws that apply to associations, whether that be codified law or common law. Common law meaning the kinds of cases that come down about these things, whether there's a statute or not. And all of those cases then apply as what's known as precedent. There's been a lot of talk lately, of course, about the big cases that affect the realty industry. That is case law that came down interpreting how you guys do business for your commissions. That is what we deal with there. You can thank the lawyers for putting that one together. I wasn't involved, so don't blame me, but still, that's the way it comes from. So that's the overarching stuff. Now let's get into what we actually deal with on a singular homeowners association when it comes to governance and how they operate. The first thing you need to know is what are governing documents within a community. Those governing documents are laid out in several types of things, but the first one you need to know is what we see here, which is known as the CC&Rs, right? That is known as the Declaration of Covenants, Conditions, and Restrictions associated with a piece of property. It's usually recorded against the particular community as the tract map. It's within the recordings of the Secretary of State and the Recorder's Office for the county. You can get those documents when you need access to them by going to the Recorder's Office and getting a copy, or by requesting them from, of course, from your management companies and or the association itself. But the CC&Rs are typically what you would think of as the constitution for that community. When you think of, we've all taken civics courses and we all understand, generally speaking, that the United States has a constitution. That thing is basically unchanging unless the entirety of the country, for the most part, as a supermajority, gets together and changes that constitution. The same thing applies to your CC&Rs. The CC&Rs apply to the properties. And in order to change that, you have to have usually a supermajority of the membership of that community vote to change those CC&Rs. So it's sort of like a constitution. It's a recorded document usually by the developer, but it can be restated afterwards by the membership. It, again, requires a membership vote in order to change it, and it contains all of the issues related to your ownership of a piece of property within the community. So if you think about it, CC&Rs deal with what you can and cannot do, rights and responsibilities of the property itself and your ownership of it. And then we move on to the next slide, Scott. Oh, and the condo plan. In California, the condo plan is used to put together some of those things. Your CC&Rs often refer to the condo plan when it comes to specifics because it contains all of the details of the boundaries for the airspace condos that we were talking about, or the easements associated with what you're going to use, or whether or not parts of the building, say the balconies or the patios, the parking spaces within the garage, if there is a garage, whether there is a garage or not, and whether that's common areas or not, and whether it's part of the units. All of those things are going to be described within the condo plan, and they're going to supplement those CC&Rs. So if you have a condominium and it applies, you can look to the condominium plan that is also recorded to determine where things fly. Now, we don't know from a legal point of view whether or not the condo plan supersedes the CC&Rs or whether the CC&Rs supersedes the condo plan, because the legislature couldn't figure out where the condo plan should apply in the hierarchy. So they literally just left it out of the list. They knew it was there, didn't know where to put it, so they just set it aside. So we usually say that because it's recorded, we keep it there. In the same way, the tract map is there for your planned developments. As you can see on the screen in front of you, the slide, all of those lots have individual homes on them, or those sorts of things. Condo plan, that's a single lot that shows all the stuff. On the tract map, every single lot within there is a singular piece of property owned independently. So there's a difference there as to what there's, but all the easements are going to be in there. The description of the distances between the lots and the lines are all going to be in there. Those sorts of things should be included in that kind of a concept. So the next one on the next slide, Scott, is the Articles of Incorporation. Again, we talk about the idea that each association is usually a corporation. In order to form a corporation, you have to file what's called the Articles of Incorporation with the Secretary of State. To do that, it's very simple. Some of the modern Articles of Incorporation are very short, usually 1-2 pages maximum. But in the old days, the last century, when HOAs started, their Articles of Incorporation often repeated a great deal of what was in the CC&Rs or within the bylaws. So they were lengthy and they were recorded at that time. More modernly, you're only going to see 1 or 2 pages, and they don't have a lot of interesting information. It just basically says we're forming the corporation, and here's where our formation number, etc. So next slide, Scott, is the bylaws. So we talked about before, the CC&Rs are different than your bylaws. And we often hear this from people who talk generally about the association's bylaws say X, Y, and Z. I can't put a patio on my home because the bylaws tell me I can't. Well, most likely that's not true. That's going to be in your CC&Rs, not in the bylaws. The bylaws, the CC&Rs govern the property. The bylaws govern the corporation. So it has all of the factors of how the corporation is formed, how it operates, how you get boards of directors, how you get officers, what the voting requirements are, what the discipline levels are, while the various different aspects of running your corporation itself are contained within the bylaws. Whereas that might be in the CC&Rs also, but the CC&Rs govern how you operate your home and what the restrictions are associated with your homes. So that's the kind of the difference there. Bylaws are not recorded. They usually have a lower standard of membership approval for amendments, and they give basically the rights and responsibilities to the board of directors on how they operate that company. That's what slide. So if you think about the idea that your CC&Rs are the constitution for the community, your board of directors is governed by your bylaws, which creates their rights and responsibilities in order to make, similar to a legislature, the laws for your community. Your board is like your Congress. They make the laws, which are your rules and regulations. Now, one thing about rules and regulations is similar to everything else we do in our society with regard to Congress. When Congress makes a law, it has to be constitutional. If it's against the Constitution or if it conflicts with the Constitution, it'll go to court, and a court will ultimately determine that that law is unconstitutional and then will be struck down. Same thing applies here. In order for the board to make rules, they have to follow the regulations associated with their governing documents, meaning the CC&Rs and the bylaws. So when they make their rules, they have to be consistent. If they aren't consistent and they're in conflict with the CC&Rs, they are essentially unconstitutional. So they would be struck down because they're not consistent with the CC&Rs of the community, which is like the Constitution. So that's sort of a reference to understand what those things are. But the board makes the laws, which are the rules and regulations for the community, whereas the membership changes the CC&Rs, which applies to everybody. The bylaws often refer to, and the board will create and adopt procedures and guidelines and rules for your enforcement. But the board ultimately is responsible for the enforcement of those governing documents within the community. Although almost all associations have the rights for individuals to enforce the governing documents against another individual with respect to certain aspects. They can't do any collections, they can't go after money and those sorts of things, but they can enforce restrictions and rights and responsibilities associated with the CC&Rs themselves, as opposed to using the board to do so. So this is where you typically see in enforcement, you see the violation letters that come. If you left your trash cans out too long and you're going to get a courtesy letter or you're going to get a fine, those things will come in the form of enforcement. And all of those procedures are set forth either in the bylaws, the CC&Rs, or by the rules and regulations of the community. And those are provided annually to each member. So usually when you're requesting to put a property listing online, so where you can start to get that, you're going to ask for all that information for escrow purposes for your disclosures. That's going to come in that packet, and all of the enforcement procedures will be listed in there. So on the next slide, enforcement hearings and fines. And again, an association cannot impose a fine upon a member unless they hold a hearing. And a hearing is typically done at a board meeting, and it's typically after they've been given proper notice by the board that they're going to be holding this hearing. In the same way that if a police officer pulls you over and he gives you a ticket, that ticket is similar to a hearing notice. It's going to be a notice that you can go to court to have a trial on your fine that you received for your violation of the law when you ran that red light. Here, it's sort of the same thing. The association caught you leaving your trash cans out, so they issue you a notice that says that you have to come to court, which is a hearing before the board, and the board is going to hear you say why you should or should not be fined for doing what you did. And of course, if you don't show up, they can just keep going and fine you based upon the information that they have. If you do show up, then you have the right to defend yourself and present what you've got in order to try to not have that. But ultimately, the jury, so to speak, the judge, is the board of directors that's going to make that decision. So that's how those things sort of work. You cannot be fined within a community unless you've had a hearing associated with that fine. So those sorts of things all come into play. Along with the enforcement process is this notion that we don't want to go to trial inside a community every time one of these issues comes up, necessarily have a hearing, especially when things are in dispute, is about how you're doing things or what you're doing associated with that. And those when you get into this informal dispute resolution, or what we know as IDR internally. So that's Civil Code Section 5900, and it goes to 5920, and it has to deal with the idea that you have to provide a simple, quick procedure for a member who wants to talk about a dispute they have with the HOA with one of the board members or maybe more. And then you're allowed to bring other people in to help with that. But ultimately, if you have this issue, you're allowed to ask the association to meet about that issue and then be able to hopefully come to some sort of a solution without having to go through all the rigmarole of enforcement and fines and hearings. You can do this informal procedure, which allows you to sort of resolve these things. But if you can't resolve them and it gets more dicey, you move into what's known as ADR, Alternative Dispute Resolution. We've heard this term before. It consists of either mediation, which is basically a glorified settlement conference, right? There's no determinations made by judges. There's nobody doing anything. It's somebody in between, usually a retired judge or an attorney, is trying to get the two parties to come to a compromise agreement. That's mediation. Arbitration is a different animal. It's like a private trial where you have somebody sitting in a bench and the two parties are going to present their cases to that person, and that person is ultimately going to make a decision. Sometimes, depending upon how you agree upon it, whether that decision that that person makes, whether it be a retired judge, an attorney, or anyone else really, that arbitration can be binding or non-binding. For the most part, you're going to see non-binding arbitration in HOAs because we don't like to give up the appeal rights. Usually, if you have a binding arbitration, you give up your appeal rights. You don't have the appellate courts to be able to say if that person who ultimately made the decision on that arbitration was either wrong in the law or something else. We don't want to give up those rights. So we want this to be usually non-binding. So for the most part, I would say 99% of the ADRs that we as attorneys for HOAs do are mediations, not arbitrations. Arbitrations we reserve for those very specific special cases. But for the most part, it's going to be a mediation where we try to settle the case before it goes to the big boy courts. So that big boy court that I'm referring to here is lawsuits. Lawsuits against homeowners, again, there's a couple of things here, but I think over the course of the last 28 years that I've been doing legal work, I'm always shocked at the number of different issues that come before HOAs and members where it turns into a lawsuit and what it's about. It can be anything that you can think of as a dispute in an HOA ends up in court somewhere, somehow down the line. Not every community, of course. There are some that are more litigious than others, but for the most part, anything you can think of. Temporary restraining orders, that doesn't mean a keep away order, like preventing somebody from coming to your community. That means things like stop what you're doing. If you're building a balcony onto the side of the condominium without approval from the association, and they shouldn't be doing it anyway, because that's exclusive use, that would be something we would seek a temporary restraining order for. If the association is going to termite your house and you're refusing to leave so that they can termite, we may need to go get a temporary restraining order against you and make you be forced out of your home. And that comes down to also preliminary and permanent injunctive relief. preventing you from building your home addition that you wanted to build because the CC&Rs don't allow that sort of thing. Or having you remove a structure that you did build without permission that's inside the setback area or the easement area where you're not allowed to build. Those sorts of things come down to those types of lawsuits. Of course, there's damages. Water intrusion claims are the most common thing you'll see about that sort of stuff. Mold and mildew, damage caused by trees, tree roots, all the sorts of things you see from that. Sometimes it's slope failures or slope creep that's going on. Those kinds of things can all result in damages. We're not usually referring to the kinds of things like slip and falls or things like that. That's usually something a little bit different. When we talk about that, that's a third party type of claim, liability claim. Damages usually come from something like a property claim or liability within the membership, not necessarily a slip and fall, although they do happen. And then, of course, declaratory relief, which is the concept that we don't really understand how this clause within the governing documents is to be interpreted. We think it's one way, the other side thinks it's another, and ultimately the judge in the case is going to determine how to interpret that clause and how to tell one side or the other how this should be read so that we can then determine the rights and responsibilities of the individuals going forward. Usually a deck relief case will apply to the entire community, not just to those two parties. On next slide, Scott. When it comes to enforcement within HOAs, the biggest issue that you see there is attorney's fees. Under the Davis-Sterling Act, and usually under your CC&Rs for the most part, they're all going to have a clause that says the winner in any dispute related to the governance of an association and how it operates is going to receive the attorney's fees back from the other side. Because of that, everybody thinks they've got a winning case, and that when they win, they get their attorney's fees and it's going to cost them nothing. HOAs especially think that when they are suing a member for violations and we want them to stop doing that, we're going to get our fees back from that individual member. That is the biggest issue to try to resolve and come to a resolution, is because obviously we lawyers, we aren't cheap. We charge a lot of money, and you take a small issue like whether you painted your mailbox the right color, it goes to court. Lawyers are spending $20, $50, $150, $550,000 on legal fees over painting of a mailbox. Each side thinks they're going to get their attorney's fees, but they can't settle it because nobody wants to resolve this by just painting the darn mailbox, because each side thinks they should be getting their attorney's fees back when they do. So it's a block, and that's one of the things we always are concerned about, is not going to lawsuit unless it's needed. So when we talk about these sorts of things, how do lawsuits come about? How does the board make their decisions? What are all the issues associated with associations and what they do? That's where we get into this concept of standards of care. Business judgment rule is the concept. It was laid down from Lido Island, which is Lido Isle, which is an association on Lido Island in Newport Beach. Behan was a property that wanted to build into the setback area closer to the water. The association didn't want them to, and there was this huge lawsuit that came about because of it. And ultimately, the court came down with this ruling that says that an association isn't going to be liable if they make their decision using what's known as the business judgment rule, which is that they act in good faith, meaning they have to be doing the right thing, right? The association's board is trying to do the right thing with acting in good faith. Reasonable inquiry and investigation is the second prong, which means that they have to seek out information. They can't just make it arbitrary or just pick a number out of a hat rather than figure out what needs to be done here. That's usually done through some sort of an investigation with experts or investigation into the documents, the history. Learn about the issue before you make your decision. And then in the best interest of the community as a whole, not necessarily as that decision applies to any particular individual. And that's one of the key factors there, is the boards are supposed to take the community as a whole into consideration when they make their decisions, not as it applies to one person. Using a reasonably prudent person standard, this is the hard part, because if a individual board member truly believes that they're doing the right thing, but most reasonable people would not believe that that's the right thing, the courts are going to apply what's known as the reasonable person standard to that board member. even though he truly believed it. If it isn't what a reasonable person would do, they're going to overrule that board member. And then, assuming that the board has acted in this way, they've used business judgment when they're going through their decision making, they receive what's known as the deference standard. This is known as judicial deference. Judicial, meaning the judge, gives deference. They defer their decision to the board, even if the board made the wrong decision. If they were doing so in good faith, if they had their reasonable inquiry and they followed the advice of experts, and they did so in the best interest of the community as a whole, but they were wrong in the outcome, or it failed, or it caused problems, even though the decision was made in the best judgment, judges will not overrule the board and not hold them liable if they did so following this rule. They will give them what's known as judicial deference, saying, I don't know any better than you do. You can make mistakes as long as you do it right. So if a board, because they're amateurs and they're volunteers, if they act appropriately and they follow that business judgment rule, the association is typically not liable even when they make mistakes. Moving on to the next slide, Scott. Okay, well, that is pretty much the majority of what we were talking about here. So before we get to the insurance, one of the things I did want to discuss is, so often we hear from realtors, why does the seller need to purchase all of the governing documents and all of this list of stuff from the management company? It's usually relatively expensive. Why is it that we want to do that when we can just ask the seller to give us those documents if they get them every year? One of the things I will advise you about that is what that is intended to do is to shift the burden. So if you receive all of the documents you're going to provide in disclosure and through escrow from your seller takes on the responsibility that those documents are accurate and correct. Whereas if you ask for them to be provided to you by the management company and you pay for them, the management company is then on the line if those documents are not correct or if they cause damage because you got bad documents, right? So that's where the burden shifts. If you shift the burden away from the seller to the management company, they need to receive compensation to pay for their insurance that covers that sort of error that they might make, but also to cover the damages associated with you asking them for those documents. So one of the advices I always give to realtors and or sellers who are going to be putting their properties on the market is always rely upon purchasing the documents for the management company, because ultimately that's where the liability is going to be. That's where the insurance is. That's where you can go when those documents are not accurate. A seller doesn't necessarily know whether changes have been made. They may not recall the changes have been made. They're putting out bad documents, and then the buyer relies upon those documents instead of the ones they received otherwise. So in that sense, that's why they charge what they do. That's where you get them and why you should be getting them from the management company and or the association, right? When they deliver those documents to you for purposes of your disclosures and escrow when it comes to associations. And remember, you always want all of the documents, meaning the articles of incorporation, the condo plan or tract map, the CC&Rs, the bylaws, all the rules, regulations, architectural guidelines, and policies of the communities. You want all that to be contained and make sure you get them properly so that you know that they are all accurate and complete, so that when you give it to your buyer, the seller's off the hook when they do so. Now, they're not off the hook for everything, but they are off the hook with regard to those records. So that's one of the pieces of advice I would always give to realtors is make sure you go through the management company to get them. And that is why they charge so much. So with that, Scott, unless we have specific questions that we wanted to ask on the legal side, it's about time to turn this over to Mike Berg so that he can talk about insurance.
Yes, I think I answered most of the questions that came through. And just a note to people, go ahead and ask the question to everybody so that they could benefit from the question and the answer. So again, we'll do our best to address them during the program, and we'll take some time at the end of it to make sure we address all your questions. But David, thank you very much for your thorough and detailed explanation of the Davis-Sterling Act. So with that, and by the way, if you want to look David up, at the bottom of the screen, you see www.cai.oc.org. That is the chapter website. David and other attorneys are on there. So as I mentioned at the start, we don't expect you to interpret this information. If a buyer or seller has specific questions on that, simply refer them to an attorney who specializes in HOA law, and you can find dozens and dozens of them at cai.oc.org. And with that, now it's time for the insurance program and our friend Michael Berg. Michael Berg, despite his youthful appearance, has been doing this longer than I have. And so he is an expert in the insurance industry. He has been working with CAI and other industry groups on the current, what we'll call insurance crisis, that I'm sure he'll cover some of this. And he is also an award winner for our chapter. So with that, Michael, please take it away.
Thank you, Scott. Bye, Dave. A little round of applause to Dave Wonkel. Thanks, very nicely done. So welcome. Thank you. Insurance. Yeah, if you're not asleep yet, here we go. We're gonna make sure to get you a nice long nap in the afternoon. Why do we buy insurance? The Davis-Sterling Act requires it. The governing documents of CC&R require it. Lenders require it. But why? Why is that a requirement? Because it's a good idea. Insurance is a transfer of the risk of financial loss. And for a small amount of money, we call it premium, an insurance company will take on a lot of that concern, that burden, such as loss by fire or water damage. For a small amount of premium, they will take on the whole thing, the whole cost of repairs. So it just makes sense. It's simply a good idea. But why do we do it? Because most people require us to do. If someone is buying a property on an all-cash sale, it's still a really good idea to suggest to them that they consider buying insurance to protect their investment. Most investors understand that, but a lot of folks I've seen that are making cash purchases say, well, I don't have to buy insurance, so I'm not going to, which exposes them to the full scope of the law, potentially. The Davis-Sterling Act gives us some minimum limits with respect to general liability and directors and officers liability insurance for an HOA. In the case of directors and officers, for a community of less than 100 units, the minimum purchase needs to be $500,000 of per occurrence liability. Anything over 100 units or 100 units or more, it's $1 million. In the general liability side, that is $2 million for an association that is up to 100 units and $3 million for an association that is more than 100 units. Most of the time, a community is going to buy general liability and directors and officers liability at the same limit, and then use an umbrella to meet these requirements. For example, we would buy $1 million of general liability and then buy a $2 million umbrella. It's a low-cost way for an association to get the necessary insurance. The fidelity bond or crime insurance that an association has is insurance for the money in the bank, so that the association can operate if we find out that someone has misappropriated or embezzled funds. The language of the Davis-Sterling Act requires 3 months assessments plus the amount of reserves for the reserve balance. I typically also include in that calculation the budgeted contribution to reserves. We see it quite often that the beginning of the year, the beginning of the policy term, if this calculation is 3 months assessments plus reserves and no money is being paid out of reserves, but only being contributed to reserves, later in the policy term, we do the calculation again, we have a higher requirement for a fidelity bond. So I like to include that little contingency. And then the CC&R and bylaws, Dave drove this home. This is where we get all the information as an insurance broker, where we get the information that we need in order to decide what to present to the client as far as insuring the property. The insurance article typically, I don't like maybe, typically is included in the CC&R. Sometimes, rarely, certainly on older communities, it might be the insurance requirement might be in the bylaws itself. It tells us what type of community we have. Do we have a condominium style? Do we have a planned development of single family homes? Are they attached townhomes? In which case they could be single family products where the unit owner or the property owner is required to insure the structure, or they could be formal, they could be configured like a condominium. The document could be written to require the HOA to buy insurance for the structure itself, like a condominium. The maintenance and repair obligations are also in the CC&R. They are not in the insurance article. Insurance and maintenance are very different things. And it's common for folks to put those together in their minds. It's important to remind any property owner that they have a maintenance responsibility that's defined in a CC&R, but that's different from the insurance responsibility. They will always have the same maintenance responsibility. But for example, in a condominium, there may be requirements in the CC&R that have the association purchase insurance that the owner is responsible to maintain, such as interior fixtures, and we'll get into that in a second. Lender requirements, Fannie Mae, Freddie Mac. The National Flood Insurance Program is used when a property is in a flood zone requiring flood insurance. All properties are in a flood zone, a special flood hazard area, though there are specific zones or specific areas that require flood insurance. This is because it's becoming more common for lenders to look for things like inflation guards, ordinance and law coverage, equipment breakdown, waivers of subrogation. Severability of interest means we sever the liability component so that if someone feels they've been wrong, they can actually sue the association under which they're actually insured. So, and then lenders want to know that the association's policy is primary. Most of this stuff will show up on the certificate of insurance that your client, borrower, what have you, is requesting from the insurance broker for the community. And if it's not, it can be easily added. So property insurance is insurance for things we can touch. It's first party, that is, it's for if I'm the property owner, I'm the first party, or I'm the insured, the named insured, and it is for damage to the things we can physically touch caused by certain events. We call them perils. Insurance brokers call them perils, or it's events. It's the fire, it is the burst pipe, it is the windstorm. I don't want to go too far into that, but bottom line is it's insurance, first party coverage for damage, the things we can touch caused by a specific event. Liability insurance is protection for third party allegations of negligence. The third party is someone else. Let's say Scott feels like I have harmed him in some way and he wants to sue me. Well, he's the third party and he's suing me for negligence. I'm going to be defended under my personal liability insurance, which is provided by my insurance carrier, who is actually the second party. Hurt feelings, like Scott's feelings constantly getting hurt. We're gonna toughen them up a little bit here. But in an HOA, it could be things like a roof leak. That's a typical liability claim where the association is responsible to maintain the roof and has some negligence in that maintenance, which leads to a leak and causes damage to a unit. The unit owner can allege the negligence of the HOA and therefore make the association liable, i.e. responsible for the damage that was caused. Most of the policies that we write today are special form policies. Back in the day, and it was funny listening to Dave say, back in the other century, which was just a few 24 years ago, but back in deeper parts of the 1900s, we used to write what's called a basic or a named peril policy. The policy would cover only the perils that were named in the policy: fire, windstorm, hail, aircraft, that sort of stuff. We would name specifically the coverage. Today, a special form policy has so many things that it covers that we don't name the things that we cover. We only name the things that are excluded. So everything's covered unless it's excluded. And then we exclude things like earthquakes, floods, rising water from established stream system. We exclude things like mold, mildew, rodents, insects, those kinds of things. We specifically list the perils or the events that are covered. It's important to note that an insurance company does not take on all of every event or every peril that could damage property. Otherwise, the insurance company might as well own the property. So the insurance company says in their contract, here's your policy of insurance. We will cover all the damages, but we're going to exclude these things. It's commonly referred to as, the perils are commonly referred to as acts of God. We don't like that, not to mention the religious and theological conversations that we're trying to avoid, but it's what did God do? Was there a fire? Was there a lightning strike? Was there a burst pipe? The specific event is what we're looking for. And the exposure to loss is to everything from buildings to the fences, walls in a community, streets, pools, business property of the community, such as furniture around the pool or in a clubhouse, landscaping, lights, monuments, any physical property. We look at the reserve study, which Scott is going to dive into. The reserve study has a list of components that the association is required to maintain, repair, replace, and insure. And so we look to that. We rely on our reserve study experts because they give us an insight into what ancillary property the association might be in need of insuring. For coverage on events or perils that are not covered or excluded, such as earthquake and flood, we buy separate policies. The NFIP is a good example of that. And then the earthquake marketplace is also available to condo associations. Single family homeowners will typically buy their coverage through the California Earthquake Authority, or CEA, but there is coverage available for the perils that are excluded. Inside of a condominium, well, going back to the CC&R, the CC&R provides us with language again that tells us what we need to insure with respect to that property. And inside of a condominium, inside of the unit itself, there are essentially 3 ways that we need to insure the property on the inside. If we stand in the threshold of a unit and we put a hand on the outside and a hand on the inside of the unit, the space between our palm is 99% of the time common area. That is property the association is responsible to maintain, repair. Ignoring the drywall that is here, because that might be on the inside, that might be the unit owner's responsibility. But this space within the walls is common area. That's association responsibility. Once we get inside the unit, if we are required to insure property on the inside, if we pick that unit up and flip it over, are we required to insure everything that stays stuck inside, such as floor coverings, cabinets, countertops, bathroom fixtures? Those items, if we are required to insure them, and we're required to insure them in their improved condition rather than what they were originally installed as, we call that all included or all inclusive. If we have to insure that property that's attached to the inside of the unit, but we only have to insure what was originally installed and can exclude upgrades, we call that single entity coverage. And if we don't have any responsibility at all to the property that's attached to the inside of the unit, we call that bare wall. In which case, if a unit needs to be rebuilt, then the insurance carrier for the HOA will cover the cost to rebuild the building up to the interior surface of the drywall. And the unit owner will be left with a concrete slab floor to put a floor covering on, or in a second floor, a plywood subfloor, and then blank wall that will require paint. The HOA's deductible is applied to every loss. It's not a bill, it's not an invoice, it's not a chargeback. It's an amount of money that is deducted, that is deductible from the payment of a claim. That's why we call it a deductible. So the unit owner may be responsible for that deductible, and it's important to have and advise the owners to purchase an HO6, a condominium unit owner's policy, because the HO6 will cover their exposure to property damage that was under the deductible. It will cover their exposure to property damage if they have, say, a bare wall or a single entity style policy. It's common for us to hear that an owner didn't buy insurance, didn't buy an HO6 policy because the lender didn't require them to buy it because there was coverage already in place for the HOA. While that is true, there's always exposure on the part of the owner, or the part of the buyer, the resident, what have you, that they will be, they do have exposure to loss, to property loss, and then also to personal property. So when we picked that unit up and flipped it over, everything that stayed stuck inside is the building property. Personal property falls out. We also have coverage for personal liability. We have loss of use. This is additional living expense if a condo owner or their renter, or a single family owner or their renter needs to move out in the case of a covered claim. They have insurance to cover their additional living expenses. Loss of use or loss assessment, pardon me, is less of an issue for a single family homeowner, but sometimes can be an issue, especially with these larger condominium association deductibles that we're seeing, $50,000 and $100,000 per claim. Loss assessment could become a factor that a unit owner needs to consider. And just to reiterate what's at the top there, HO6 is a condominium unit owner's policy, and HO3 or an HO5, you might hear that term as well, are single family homeowners policies. And they're just applied to the various types of risk depending on what you have. I don't know why comprehensive auto coverage is on this slide, Scott. I don't know that fits. So maybe there's an edit due. I mentioned the fidelity bond or the crime coverage that the association has in place. Again, this is for embezzlement or misappropriation of funds. Who is an employee of the association? Pretty much anybody that has access to the funds is defined as an employee. Some insurance companies write what's called employee dishonesty coverage. For example, Farmers Insurance writes employee dishonesty coverage, and then they endorse the policy to include the community management firm as defined as an employee, so that any member of the community management company absconds with the funds, the coverage would trigger. Social engineering and deception. This is a new thing that is becoming much more prevalent. Social engineering is spoofing your email inbox and not doing anything until there is an email that they want to intercept. And then the fraudster will intercept that email, change some information in it, and make you think you're replying to the person you want to reply to, but you're actually replying to the fraudster. And people will give out a lot of information or send money in the form of a wire transfer, for example, through stuff like social engineering. So it's important to have two-factor authorization, cyber liability insurance for your businesses to protect you from this type of exposure. Again, limit requirements in the Davis-Sterling Act. If the Davis-Sterling Act, and most lenders, by the way, will follow the Davis-Sterling Act, 3 months assessments plus reserve. If the Davis-Sterling Act requirements are less stringent or less strict than those in the CC&R, you need to follow the CC&R requirement. We will follow the more strict requirements. So while the Davis-Sterling Act may say 3 months assessments plus reserves, a CC&R document might say 150% of the budgeted annual reserve contribution. Well, that could be a much larger number, or 150% of the budgeted annual expenses of the community. That could be a much larger number than just 3 months assessments plus reserves. So we need to abide by the CC&R requirement if it's more stringent. General liability insurance, again, third-party damage. We include coverage for advertising and personal injury. This really comes into play for an HOA that may have a newsletter and would cover libel, slander, something like that. Well, actually libel in a newsletter where someone feels there was something misspoken about them that defamed their character and they want to file a claim. Products and completed operations you won't see very much used in an HOA policy, though it's part of the general liability coverage basic form. Medical expenses are is coverage for if somebody has a trip and fall and they go to the doctor and they say, I had to spend $3,000 on my doctor's bills and my x-ray and what have you. The medical payments is basically a checkbook, an open checking account for an adjuster to write a check up to $5,000. It doesn't penalize the association. It's it's no fault coverage to the association, but it helps that issue get resolved quickly so it doesn't become a bigger claim with larger demands from the injured party. Auto liability, in particular, hired and non-owned auto liability, you'll see on an HOA policy. That's insurance for the association if they rent a car or someone is in an accident while on association business using their own car. If an association has its own vehicle, there will be a commercial auto policy in place. Directors and officers liability is professional liability for the board of directors making decisions on behalf of the community. And it's important within a board of directors that they follow the business judgment rule that David so eloquently outlined for you earlier in the presentation. Umbrella or excess liability, I mentioned that a hair earlier. This is additional liability insurance that goes over more than one policy. So it goes over the general liability policy and the directors and officers liability policy and a commercial auto liability policy if there's one in place. It's a cost-effective way for an association to buy more insurance. Workers' compensation insurance you'll see on HOA policies quite often, even if that association does not have an employee. Of course, if the association has an employee, they're going to be required to carry work comp. When they don't have an employee, it's common to protect the possible exposure that a contractor's employee or someone else could be deemed an employee of the association. And if you want to look into that, you can look at Hyman versus Work Comp Appeals Board. That is the landmark case that started us selling work comp for no employees to condo associations. Incidentally, on your homeowner's policy for your HO6 or your single family home HO3, HO5, there is workers' compensation coverage included in those policies for the instance where someone might have not an actual employee, but has someone under certain conditions that could potentially be their employee, such as a cleaning service, a landscape service. There are language about how much you can pay that person in a month and how many hours of work they can do for you in order to qualify for that coverage if it's needed. If you exceed those limits or those contingencies within the policy, the suggestion is that you have an employee and you need to buy a work comp policy for yourself. Cyber liability. This is insurance for an association should someone allege that their personal information was stolen due to some lack of cyber security that the association may or may not have in place. It's less important for a condo association because most of the time the association doesn't maintain personal information for an individual. It's more important for community management firms because they might be processing payments electronically, holding on to bank information, dates of birth, that sort of stuff that could be really valuable to a fraudster. And then employment practices liability. This is insurance for, say, the wrongful termination of an employee. Typically, it's included in the directors and officers coverage. Typically, it's not something that an HOA has to worry about because most associations don't have employees, though larger communities, high-rise communities have a tendency to have their own employee base because it's easier than hiring a management firm, or it's cheaper than hiring a management firm. They can monitor it themselves. Additional insured requirements. This comes up quite often in the sale process because the lender will be asking, does the association policy name community management as an additional insured? The answer is yes. But what does that mean? It means that if there is a lawsuit that involves the community manager, the manager will be included in the defense by the association or by the association's insurance carrier. The community manager still has their own professional liability, and if they breach their own professional liability, then they have that exposure. But most of the time, or really all of the time, a community manager should be working for a board of directors, supporting them, not giving them direction, but taking direction from them as their contracted service provider. So the community manager says, okay, or the community manager of the firm says, okay, we're going to take direction from you. But if you give us the wrong direction and somebody sues us, we want to be defended by your insurance policy. That's what the additional insured does. It doesn't give them rights over the policy itself. It just includes them in the defense. And it's included in the general liability and the D&O. And then we talked about how we include the manager as an employee if we need to in the fidelity crime coverage. Oh, I have a different slide there. Again, workers' compensation, no employees. CC&R language might require, typically does not unless there is an employee. State employment laws have changed dramatically over the last few years, going from the 1099 independent contractor world that we used to be in, with a number of tests to say that this is a 1099 or an independent contractor, to really, we only have 3 questions that are asked when it comes to being an independent contractor. And 9 times out of 10, someone who thinks they're a contractor or someone that the association thinks is a contractor is actually an employee. And this is another reason why workers' compensation insurance for that HOA is critical. I don't have any nice little anecdotes to add that Dave did. If there are, I noticed you got that one question about co-ops, Scott, thank you very much. I don't know if there's any other questions that folks have. We have a few minutes.
Yes, if you do, feel free. He'll hold on for just a couple moments if you have other questions. And also, if you want to look and find him, cai.oc.org. Michael Berg is on that website with additional insured. So as we've talked about, we don't expect you to remember this and become an expert on insurance. So if you have a question about insurance with whether a buyer or seller, then refer them to somebody on this website who specializes in HOA insurance. So it's very important, of course, particularly on the buyer side, if you're going to buy insurance, to understand what kind of insurance you're going to need to supplement the HOA's insurance. So we would certainly recommend that when you're working on the buyer side, you recommend that they speak to somebody who specializes in HOA insurance, who will have and get a copy of that HOA insurance. As David mentioned, you want to get that documentation from the HOA through the escrow so that the chain of custody and the information comes from that source. And then once you have access to that information, it can be reviewed by whatever expert you choose or your buyer chooses, whether it be a legal counsel, HOA, CPA, financial expert, or of course, an insurance expert like Michael. Thank you again, Michael. Appreciate all your opportunity and wisdom in this effort. Okay, now we're going to talk about the money. I know that's always important for people. Let's talk about the money. So HOA finance. First, we're going to talk a little bit about just the HOA finances. Then we're going to talk about probably the most aspect, save it for the last, the reserve study. So in HOA financing, you ask the simple question, what would you want to know before you buy into an HOA, right? What makes an HOA fiscally sound? Well, it's understanding the financial reporting and documentation. We're going to talk a little bit about what's required. The Civil Code has several sections. Again, if you weren't at the start of this, we have given you a copy of the Civil Code. You can look up the sections and what is required, but the Civil Code requires a certain level of documentation as it relates to financial information, and that's required to be given to the membership and then, of course, passed on to a potential member. And then how they go about preparing and adopting their budgets. Are they listening to their professionals and adopting what they recommend, or are they just going with what they feel is the cheapest or the best option? That's a very important aspect. We'll talk about that in just a moment. And then the use of the reserve study as a tool and reasonable funding levels. You've probably figured out by now that there is a lot more scrutiny on an association's finance and reserve study, both from the lending community and from the insurance community. So you want to make sure that your associations are using the reserve study as a tool and are achieving reserve funding levels that are reasonable. And again, we'll talk about that in just a little bit. So some of the basic financial information that's required is a balance sheet, income and expense report, check register, general ledger report, reconciliation report. And again, if you are in the area of understanding these documents or your buyers are, sure, take a look at it. If they're not, then of course they should get some guidance on that. But this documentation is available for the members and potential members to make sure the association is keeping up with all of their reporting obligations. And that continues on a general entry report, a prepaid report. So an association is required by law to accept prepaid. So if your assessments, particularly in limited associations that have, like $50 a year kind of numbers, you can prepay all of your assessments, and the association keeps that on a tab. But more importantly to that is the delinquency report. So if somebody has not paid their assessments, then that's kept on a delinquency report, just like a regular business would, so 30, 90, 60 days, whatever it may be, they keep track of that, of course, so that they can go back and get that information. But it's very important for a real estate professional, particularly when you're taking a listing, to make sure that that report is within the limits. So specifically within FHA, it's 15%. So if you're on a 100-unit complex and 15 or more members are delinquent on their assessments, well, you're not going to get FHA financing. So you can ask for that right up front. By the way, this is one of those documents that's available up to 10 days with notice. So a seller can just simply ask their association for a copy of the delinquency report, and then you as a professional realtor will get access to that through them, and then can determine whether you're going to have a problem securing financing on that property by its delinquency too. The annual budget report is required to be given again annually, as it would suspect, 30 to 90 days before the beginning of the fiscal year, and it includes a number of items, and one is, of course, the pro forma operating budget. And then we ask, well, what are the limitations on these? Because, of course, assessments can change from year to year. So what the board has authority for on the regular assessments, that's the monthly or the quarterly or annually, whatever they're distributed at, is up to 20% without membership approval. Above 20%, they have to go to the membership. And that amount would be listed in the CC&Rs. Typically, it's a majority, sometimes it's a supermajority, but nonetheless, when they go above these amounts or need to go above these amounts, they have to go to the membership. But that's kind of not, 20%. So let's say we start off, I don't know, we'll call it $100 so I can do the math, right? So it starts at $100. The next year it goes to 120, then it goes to 144, and then it goes to 172. And then, wow, in year 5, it's at $212. So you can more than double your assessments because of the compounding. So while 20% may seem limited, it can add up pretty quickly. So that's why the Civil Code gives these limitations, to make sure buyers have an opportunity to adjust to these. They can also, the board in talking about, can assess a special assessment up to 5% of the budgeted gross expenses. So whatever the budget is for the previous year, up to 5% of that for that current year can be assessed as a special assessment. That's a one-time. So these special assessments and these regular assessments can be both done in the same year. So you can increase the assessments by 20% and get a special assessment. And there is what's also known as an emergency special assessment. And by the way, I've been doing this a long time. I've had a lot of people paying these monies, and none of them really found it all that special. Nonetheless, that's what they call it. So an emergency special assessment is unlimited. However, there's going to be some requirements for that. One is has to be something that was unknown. So, typically speaking, a roof, well, we knew we needed a roof. You can't special assess for that. But if you had a component that failed that you didn't anticipate, or something that was unforeseen. So for instance, a few years ago, we had this balcony bill law that passed, and people had to get these very expensive balcony inspections by a structural engineer or an architect. So that was unknown at the time. So these kinds of things. The other is that it proposes a threat to life or limb. So if you've got a part of the property that is in such disrepair or as an issue to somebody for life and safety issues, well, then the board can assess a special limit, unlimited amount, whatever's necessary to make that repair. As I mentioned, you have several reports that are given on an annual basis. The annual policy statement is, as it would name, is all of the policies. So that includes the policies that David talked about earlier, about whether your parking policy, whatever your fine policy are, all of these, when your pool operations are, those are policies that are given as part of the annual policy statement. And then as Michael talked about, your policies. So whatever insurance policies you have. So this has to be given each and every year to the membership. And then that annual budget report. And that annual budget report, as the name would imply, it's your pro forma operating budget. So that's going to list the association's income and all of the expenses. So of course, management fees, your landscaping fees, your insurance costs, your utility costs. So everything that the association spends money on is going to be part of their pro forma operating budget. And that's what's determined to get their revenue, because the Civil Code has a section, it's called a zero-based budgeting. So the association is required by law to collect enough money, it's called sufficient in the Civil Code, to meet their obligations under the governing documents. But then it turns right around and says the board can't collect more than is necessary. So it's why it's a zero-based budget. So you have to collect just enough, but no more than is necessary. And that is all part of your annual budget report, delivered 30 to 90 days before the beginning of the next fiscal year. And then what we have is the year-end financial report, and that's after the year, a look back, and that would be a review or an audit. It's delivered 120 days after the end of the fiscal year, whatever it might be. And so that gives the opportunity for the board and the membership to see what was done past year and that it's been reviewed by a CPA. We talked about earlier some of the disclosure documents that we have out there. 4525 in the Davis-Sterling Act, we'll talk about the disclosures that are available to a prospective purchaser. 4528 are the document disclosure summary form that David was speaking about. So you list the number of documents that you want, and then they will give you a fee for that. So the association will have to identify what documents and what fees apply. So that form is in the Civil Code. So you just simply check the boxes of the information that you want. And as David mentioned, it's worth the cost, because you don't want to be in that chain of command. So if the seller gives the information, well, now they're liable to make sure it's accurate. And as David spoke about, things can change, right? So maybe the CC&Rs didn't change, but the policies could have changed, right? They may have changed the hours of operation of the pool. They may have changed the parking policy. So if there are changes in the community that have happened and the seller is unaware of these, well, getting the updated documents is the reason that you want to invest the money to get a new set of documents. And then 4530 is the information to be provided by the association, what they're required. So a member can simply ask for information. As I mentioned earlier, if they want to get the budget information, see what the delinquency report is, well, they just simply ask for it, and the association has 10 days in order to fulfill that request. So all of that information and the timelines are outlined in 4530 of the Davis-Sterling Act. So again, I encourage you to download that document from the chat room and keep it on file. Now we're going to talk about reserves. This is really the big ticket stuff, right? This is really when it starts taking effect. So a reserve study is made up of two parts. One is the physical analysis and the other is the financial analysis. So the physical analysis is what's there. What is the community responsible for? And that could be the buildings, the roof, the plumbing, and in some cases roads, recreation centers, pools, spas, etc. So the list can go on, but what are the physical assets of that particular community? And then the financial analysis, which takes, okay, how much money are they starting with, right? What are their future obligations to repair that roof, those roads, whatever else may be in that, and what contribution rates are going to be necessary over time to meet those obligations. So the physical analysis and the financial analysis. The physical analysis is made up of a component inventory. So that's just simply a list of those assets. It will typically have them, listed, whether it's systemically or geographically or whatever it will list, again, roofing, plumbing, mechanical, etc. And then it will have a condition assessment. What shape are they in? So in a brand new building, well, you would suspect that the condition is pretty good. It's all brand new. But when you get into an older community, particularly one that's 30 or 40 years old, very few of those components are original. So is this the second or third roof that we're talking about? So if it's the third roof on a 40-year-old building, well, it might be in pretty good shape because it might be relatively new. However, if it's the second roof or even the first roof on a 40-year-old building, well, its condition is probably going to be pretty worn because few roofs last more than 40 years. So the condition assessment is going to talk about each one of these specific components and what condition they're in from that point. And then they will assign a useful and remaining life. So how long does that roof last once it's installed? And then how long is it expected to last from that point forward? Now, of course, you can't do this with any great deal of accuracy, but you can be reasonably close. So if somebody says that it's expected to last 20 years, well, the chance of it failing in 4 or 5 years is relatively remote. The chance of it failing in 10 or 12 years, also pretty remote. The chance that it could fail in 17 years, yeah, that's certainly possible. But by the same thing, it can go longer than expected. So if it's anticipated to last 20 years, well, if it's still functional in 20 years, leave it in place, right? Let it go. So it's not expected, but it could go 23, 25 years. Of course, that's not unreasonable. But if something's expected to last 20 years, the chance that it's going to go 30 or 40 are also very unreasonable. So it can get within a reasonable prediction of when these expenses will occur. And that will drive, of course, how much money you need to set aside and keep and maintain throughout that 30-year term of the reserve study total. Percent funded. Percent funded is a term that they use to give you kind of an order of magnitude on where an association is with its funding. So for instance, 0 being the worst and 100 being the best, anywhere in between, you can gauge for yourself what that is. So if an association is 25% funded, well, you can anticipate, well, that's not very good. So for those of you who may be, I'll just say over 40 and considering retirement sometime in the next 30 years, well, you know, what if your retirement account was only 25% funded? Well, that would be a problem, right? So same thing with association. It gives you an order of magnitude, whereas 70, 80%, well, they're maybe not there. They're not nirvana as it would be, but they're getting close. So it gives you an order of magnitude where an association is in its current status on its funding levels. And again, it can vary greatly. So a brand new association, you might suspect that it'll be in good condition, but if it wasn't left in good financial condition from the developer or the early board, well, yeah, you have some newer associations that are poorly funded. But by the same token, I've seen 50 and 60-year-old associations that are well funded because they've been well managed. They have good, prudent boards of directors who bring in enough money as necessary to maintain the structures and then, of course, set it aside as necessary. So it's very important that you look at these pieces of information within the reserve study. And by the way, they're all required by law. And then, of course, the most important is a funding plan. And that's a recommendation for a reserve contribution rate. So, of course, you have your assessments that are designed to pay all of your operating expenses. So again, your management fees, utilities, landscaping, all of that. And then there's money that you set aside to go into reserves for future needs, such as replacing the roofs, the roads, and other items. So the funding plan will give a recommendation for how much the board should be setting aside for each of these 30 years. And again, it's a 30-year projection because if you don't go out 30 years, it won't capture the big ticket stuff. So for instance, if we only look out 10 years, well, a lot of roofing material goes 20 or 30 or more years. Well, it wouldn't capture that. Same thing with roads or other infrastructure items. So the funding plan is designed to show what's going to be necessary from a contribution rate over a 30-year plan. Also, again, required to be part of a reserve study. The calculation methodology is also listed in the Civil Code, and it's pretty simple. So we'll take that top item there. So let's say hypothetically we've got a roof. It lasts 30 years. At this point, it's 20 years old, so its expected remaining life is the 10 years. Its replacement cost in today's dollars is $57,000. So it will be inflated. So 10 years from now, of course, it will cost more than $57,000. But right here today, as we're speaking, it's anticipated to be $57,000. And then you have an annual depreciation, and that is nothing more than the cost of a component divided by how long it lasts. So $57,000 divided by 30 years means $1,900 a year in annual depreciation. So even though that roof doesn't need to be replaced, well, every year you need to set aside $1,900. So at the end of the 30-year term, you have the $57,000. So at this point in time, the 100%, the fully funded amount, the amount of accumulated depreciation, as they call it, is the $38,000. So at this point in time, if you've got that roof and it's 20 years old, costs $57,000, you should have $38,000 set aside. We do this calculation for each and every component. So you see the water here, 10 years, 5 years remaining at $1,500. That annual depreciation is $150. So right now, halfway through its life, you should have the $750. Gate operators, same thing, expected 12. Currently has 7 remaining. The $3,100 equals the $258 a year. So at this point in time, you need the $1,290. So looking at those totals. So the total cost of these 3 components is the $61,000. However, to be fully funded, you only need the $40,040 that it shows in that last column because that's the accumulated depreciation to this point in time. And then as time goes on, obviously you will continue to contribute to the reserves so that you have the monies. Now, one thing to look at and be very specific in your reserve study is the annual depreciation, that 2308 that you see there in the gray. That's because if you're setting aside $2,308 every year, you're keeping up with the depreciation. If you're putting less aside, well, then you're falling farther behind and you're creating what's known as negative equity, right? So we're less than 100%, whatever that dollar amount is, that's negative equity that future members or the current members that continue on are going to be responsible for. Whereas if you put more than the 2308, you catch up. So if you're starting from a poor funding level, say that 25%, well, now you're going to need to put more than the 2308 away because you're going to depreciate at the 2308. So to catch up from being behind, you're going to have to put away more than the 2308. So you want to make sure that your contribution rate at least equals your annual depreciation. And again, depending on where your starting point is, on a good level or a poor level, it may vary from that up or down. The types of studies that you'll see out there, full study. That includes, as the name would imply, everything. That includes the site visit, the creation of a component inventory. So the analyst will identify the various components the association is responsible for and create that inventory and their quantification. So, 5,000 square feet, 300 lineal feet, whatever the calculation methodology is, you'll know how the calculation is made. And then that condition assessment, are they in good condition, fair, poor? How long are they going to last from this point forward, those life evaluations? How much does it cost, right? In today's dollars, as we mentioned, it's going to be inflated in the future, but how much does that particular component cost today? The fund status, that percent funded on how much money you should have versus how much money you actually have. And then the funding plan, what's the recommendation of the contribution rate over the next 30 years? Then they have what's known as an update with a site visit. And so that means we've already got a component inventory. We don't need to recalculate that. So we use the existing component inventory. We're going to verify it, not re-quantify it. And then we're going to do the same thing. We're going to condition assessment because, of course, things change. So are we going to just simply minus the elapsed time, or are we going to move it up or down based on maintenance that it's received or other conditions? So we're going to reevaluate the condition, provide them with new life expectancy, new valuation estimates, because again, everything doesn't go up consistently with inflation. I'll give you an example. Roads, right? They're based, of course, on petroleum costs, right? So if petroleum is high, the roads are going to be higher. And then it goes down, it goes down. So just simply using an inflation factor isn't sufficient. You need to reevaluate and find out what those new cost estimates are going to be. And then, of course, recalculate that fund status. How much money do you have versus how much you should have? And then figure out a funding analysis over a 30-year period. And then there's what's known as an update without a site visit, often called a desk consult. So they don't go out to the property, they just take the information in. So they're going to take the elapsed time and delete that from the life expectancy. They're going to take in new information, such as, how much are they putting into the contribution rate? What's their beginning starting balance? And they're going to create a fund status and a funding plan based on that information. It will also identify and assess conditions, and most of the site assessments are going to have information and a photograph. So if you're not familiar with it, centrifugal pump or something like that, generally it'll have a graphic or a picture of it so you can understand it, and it will give you that basic information on what its function is, where its location may be, and will often give you information on how best to protect that asset. And we put that all into a big giant thing known as a component inventory. And so you see on the screen here, we've got it, roof, structure, paint, etc. And then you give the approximate quantity. So again, whether it's square footage, lineal footage, number of units, whatever it may be, the life in years. So how long it's expected once it's brand new, how long it's expected from this point forward. And then of course that current cost, its annual depreciation. So you should be able to quickly identify the components that are in the community and where they are in their life cycle. And then we give them those costs. And well, where do these costs come from? Ouija board? I don't know. Well, there are several cost sources that we will use. One of them is known as the Construction Estimators National Cost Guides. These are widely used and they're very robust. So virtually everything under the sun is going to be in these cost guides. They're often zoned for geographical reasons. So of course, it may be more expensive here in beautiful Southern California than it may be in other parts of the country. So they're reasonably accurate, but generally speaking, there's other sources that are more accurate. So for instance, in-house databases. Most people in the reserve business have access to information on a regular basis, so they keep their own in-house databases based on where they operate. So they generally have a pretty good database of costs. However, the most accurate are going to be from the association themselves, right? An actual expenditure like, oh yeah, we just replaced the water heater here, because that's going to have all the entire scope of service. So did you buy the best water heater, a medium level water heater, or the cheapest water heater that they make? Does it have the best warranty or a medium warranty or the worst warranty or the least warranty that may be available? So all of the variables that will go into the cost of each and every component will be known in that actual expenditure. Also written estimates. So we're about to replace our water heater, or we're about to replace our roof. We've gone out, we've gotten multiple estimates, and here they are. And again, that will show the scope of work and whatever choices the board makes. Because again, when you're remodeling your kitchen, well, yeah, we want to put in the cheapest cabinets, the least expensive cabinets, whatever it may be, that's going to be part of that written estimate as well. And then our funding plans. So what's the association's financial position? And it affects a lot of things. One, property values, and we'll talk a little bit about how it really impacts the property values in a moment. But of course, the association's financial picture has an impact on the financial property of the property. The future assessment increases, right? If an association is starting from a poor funding level, 20, 30%, well, that's very poor. That's a high risk for a special assessment. So of course, your future assessment increases are going to need to far outpace inflation, because you need to not only maintain what's going to continue to deteriorate, you need to play catch up. Whereas an association which is well-funded, say 75, 80%, well, you can anticipate, yes, it's going to have inflationary adjustments because things are going to go up, but you're not having to play the catch-up that you are for a poorly funded HOA. So your future assessment increases, you can anticipate to be at or near inflation levels. And then, as we mentioned just a little bit earlier, and we'll talk about, is FHA availability. Now, in Southern California, with the average price, you don't have as much FHA financing for unit purchases. However, it is still the biggest source of purchasing in what we call entry-level housing. So a lot of the smaller condominiums, the places in the less desirable, maybe not on the beach, but beach adjacent, as we would say. So FHA financing is still used quite a bit for purchases. But that also applies to the use of your equity. So if you want to take out a loan and say remodel your kitchen, well, FHA eligibility is going to come into that. Let's say you're a veteran, right? And you want to take advantage of some of the great opportunities that they have and send your kids to college. Well, you won't be able to use your equity in your home if your association doesn't qualify for FHA financing. So it's very important to maintain fiscal stability in order to maintain the best financing available. The association's ability to maintain the common areas, what you guys would probably call curb appeal, right? So if you don't have the money to paint the buildings, well, of course, it's going to look sad and poor. And if you don't paint a lot of things, so stucco, maybe not that big a deal, but if you don't paint the wood, now you're going to have damage to the underlying material. So things like wood and iron, they need to be painted on a regular basis so that you don't damage the material underneath and cause more expensive repairs down the future. So it's the ability to maintain the common areas, which keeps you from having to go to bigger expenses, right? And then, of course, maintaining that curb appeal, which is going to be most attractive to the buyers. And then the association's ability to manage expenses. As I said before, nobody knows what the future will bring. We can reasonably prepare for it, but there's always going to be surprises. So what happens if your roof fails before it was expected? Well, now you have this very large expense that was anticipated at a certain point in time. Well, no, it came sooner than expected. Oh, well, what if it was more than expected? We anticipated that it was just the roof, but we found out there was damage to the underlying sheathing. So now not only do we have the roof repair, we have structural repairs to maintain that structure so that we could put a new roof on it. So it costs more than expected. Not expected at all. Sometimes things fail that we don't anticipate. So it allows that. And then, of course, insurance deductibles. So having enough money there to meet the deductibles if necessary. And then, of course, once you get the lesser amount from the insurance claim, you have these repairs to be done. So you want to make sure you have money in your reserves to make repairs after a claim. So I hear this quite a bit, if you've been in HOA meetings at any point in time, you'll hear somebody stand up, when I was on the board, I never raised dues, and they brag about that. Well, that's actually not a very good idea. So here we have never raises dues vistas, right? And so you see in year one, the total assessments were anticipated to be $100 because they had $90 on their operating expense. Their reserve contribution is $10. So you add the 90 and the 10, that comes up to $100. And so that's what prudent management would be. And in this case, they adopted that. And they said, okay, we're going to have $100 in total assessments. We're going to spend the $90 on our operating expense, and we're going to contribute $10 to the reserve contribution. And then Mr. I never raised dues gets onto the board, and here's what happens. So the next year, of course, we have inflation, right? We've had it for thousands of years. It's just a common occurrence. It goes up, it goes down, but we always have inflation. So in this case, we're going to use a just standard 3%. So of course, now your operating expenses are $92.40, and your reserve contribution is $10.60. So the recommended requirement is the $103. Now, I want you to think what happens, just hypothetically, if you don't pay some of these. So if you don't pay your landscaper, what do you think happens? If you don't pay your insurance, what do you think happens? And if you don't pay your utilities, what do you think happens? Well, the same thing in an HOA happens at your own home. They will stop mowing your lawn, they will cancel your insurance, and they will cut off your utilities. So associations pay their operating expense because, of course, the consequences for doing so are so bad. So in this scenario here, they didn't increase their assessments to the 103 as it was recommended. No, but they still paid out their operating expenses because you got to pay those, right? So now they no longer have the $10 that they were paying. They certainly don't have the $10.60 that was recommended. No, what they have left over is $8.60. So they're going backwards. They're going the wrong way in their reserve contribution. And so you can see in year 3 there, $106, and you look down at that bottom total, that $5.60. So you see it doesn't take very long for an association to maintain their assessment as a level plane, as like just maintain it, don't raise them dues. And then they're going to pay their operating expenses, which are going to go up with inflationary adjustments. And so they have less and less money to put aside into the monies for reserves. So in this scenario you see here, in just a 3-year period, they've got half. They're roughly half of what they should. So you see it doesn't take very long to have those assessments catch up, and now you're drastically underfunded in your reserves. So of course, the prudent thing for an association to do is raise assessments every year. I know people don't like it, but when you wait several years and you go up 20 or 30%, that's when they really hate it. You increase it 2 or 3 or 4% a year. All right, yeah, nobody likes it, but nobody's gonna, storm the gates because it's inflation. It happens everywhere. Most retirement programs, of course, Social Security, all these things are adopted for inflation. So you should increase the assessments on a limited amount every single year so that you can continue to maintain your reserve contribution, which again is the big financial picture of your association. So what are those implications? We talked about unit sales, refinance, an equity loan, or even a reverse mortgage. They all typically require on some level of scrutiny from a mortgage company. So just the simple ones for FHA and VA. And again, a lot of private lenders, they want to mitigate their risk. A lot of private lenders are adopting these. So these are going to be consistent for any federally backed loan, and a lot of private mortgages are funds available. So a contribution rate and reserve fund balance to equal 10%. So if the association is collecting $100 a month, well, then at least $10 of that needs to go into the reserves. A delinquency rate less than 15%, because of course, if the association can't collect the monies that it's owed, they're not going to be able to maintain their building. That's going to cause all kinds of issues and may result in a massive special assessment. So associations that have high delinquency rates are going to be denied opportunities to have proper funding. Owner occupancy rate of 35%. It's known that the people in owner occupied typically maintain their buildings a little bit better, both physically and financially. So if you get a high non-owner occupancy rate, that may put you outside that limit. A maximum of 49% non-residential space. So as we know, particularly in the beach areas, we have a lot of mixed use communities. So they want to make sure that the majority of it is in a HOA setting or a homeownership versus a commercial environment. A reserve study within the last 12 to 24 months. So again, the reserve study is really, the financial picture of the HOA. That's the most important financial document an HOA has, because that's how much money they should have. And the older a community gets, the more important it is, just like the older you get personally, how much you have in your retirement account is an idea of where your financial standing are. So both the mortgage industry and now the insurance industry is asking to see copies. And for FHA guidelines, anything that's over 12 to 24 months, depending on the community, they're going to ask to have an updated reserve study. And then no more than 50% FHA-backed mortgages. The FHA learned this back in the 2008 housing crisis. They had a lot of communities where the FHA, 60, 70, 80% of the mortgages were backed by FHA. And so they wound up having, of course, to own almost an entire HOA. So they do cut it off. at 50% for FHA-backed mortgages. So this is just a partial list of some of the requirements that both FHA and now some private lenders are going to be requiring. So every reserve study in the state of California has to have what's known as a reserve summary, and that has some basic information that's in there, some general assumptions. So what's the year that we're talking about? Each association operates on a fiscal year. So what fiscal year are we talking about? An inflation factor, as I mentioned, inflation happens every year. So we're going to put an inflation factor. Interest, right? If you have some money, you're going to make interest on that. And good news, the Fed just changed their rate. So now it's gone down. So our earnings have gone down, but nonetheless, we're still going to have some earnings, less taxes. And so we want to calculate that into the process. And then, of course, your beginning reserve balance. How much money are you starting from? Because that's going to give you your percent funded. So you see that at the bottom of the screen, the 35 and the 38%, that is going to be based on what your liabilities are versus how much cash you have. And then the most important number, the divisible number, the 48, the number of units that you're going to divide all these liabilities are. And then the reserve contribution. So you see in that middle section, it says, okay, what are they doing right now? And in this particular scenario, they say, hey, we're putting $3,000 a month away, and that works out to about $62 per person. However, the reserve analyst is recommending that you increase that to the $4,800 and $101, which of course, keep your calculators in your pocket. That's $39.31 to each member. So these important recommendations are to know whether the board is following prudent advice. And then, of course, any special assessments, that's important. And then the future assessments, how much are they going to go up? And then that factors into how much of the total assessment. So that middle column there, the assessment. So right now we've been told it's $21,000 a month and about $442 a month per unit. Well, that's an important number, that 442, because generally speaking, and you guys probably know this, that most people buy as much home as they can afford. Right? Until you get up to the billionaire class, most people are buying as much home as they can afford. So if our assessments in this case are the 442, let's say hypothetically I qualify for a $3,000 loan. Okay, terrific. Good for me. I can buy $3,000 worth of house, depending, of course, on how much down payment and other factors in. But at this point, all right, it's $3,000. Oh, well, no, I've got this contribution rate of the 442 for my assessments. So now I can afford, what does that work out to be? $2,558. So now I can buy like $2,500 a month in a loan or a property because, of course, the same other factors, I don't have any more down payment. So that's going to come factor into it. So if the association has assessments that are outside what we call the market rate, that's going to be problematic. So if the association I'm looking at is 442, if other surrounding communities with similar amenities and so forth are also in the 400, 450, maybe 500 range, well, I'm pretty close to market rate. I'm going to be fine. However, if I'm 442 for this particular association and market rate is $300, well, I'm not going to sell many units in there because people are going to be able to buy more home for their money in a competing HOA that is less. By the same token, if I'm under market rate, I'm looking good. So if the rest of the community around me is $600 and I'm 442, okay, great. I can qualify for more homes. Now, that comes with a caveat that, are you really funding enough? So an association that is way under market rate, that could be a problem, signaling that they're going to have massive special assessments in the future. And of course, if it's way over, you're already in that problematic. So you want to be able to take a look at what that association's assessments are and how that compares. Now, since you're all realtors, of course, you have access to the MLS, and that will tell you what everyone else's assessments are so that you can compare it. So you want to make sure that the association is consistent with the market rate, because again, if it's already too high, going to be problem having sales. And if it's too low, well, that will probably be an indication that they're looking at special assessments into the future. We also calculate, because again, the Civil Code requires it, on what the percentage is on how much you're putting away, and of course, what that change of assessment is. So you see that line item in order to effectuate the change that this analyst is recommending, you're going to have to increase the assessments by 8.89%. So that 442 has to go up 8.89%, or that 3931 that we see in line item H, in order to effectuate what's recommended. Now, it's important to know that that 8.89% is absent of what may be necessary for the operating expenses. You've heard through Michael and others that, of course, insurance costs are going up, utility costs are going up, inflation is starting to impact landscapers and other maintenance folks. So you may need to increase it more than the 8.89% to accommodate for what is necessary for the operating budget expenses. This just focuses on the reserve fund. And then that accumulated depreciation, as we talked about, it's where you are at this point in time. So this particular association at this point in time should have $480,000 in the bank. Okay, that's what they should be on a per unit basis. It's about $10,000. Okay, well, if you look up at line item D, remember that beginning balance, they have $172,000. Okay, well, what does that mean? Well, if you take the 480 and you minus the 172, you get that overage or deficit. So that total, as you see there, is 308,699. So the association is negative equity or upside down, however you want to call it, but they have $308,000 less than they should have, which works out to about $6,000 per unit, the 6,431 that you see there. Now, that's good and bad news. The good news is, well, $6,000 in a market that has an average of about 800,000, well, again, that's less than 10%, so that's negotiable. It's probably worked. If you've been in the industry at any point in time, you know that that number in a buyer's market, well, guess what? You might get some movement on that number, right? If it's in a seller's market, you probably don't. The most important thing is that that number is there and it's disclosed so somebody can't come back later and say, hey, I didn't know. So in this case, you see the 6,431, that's how much it is. That's something that you can work with. Also, it's below the $10,000 limit for FHA and some private lenders. So FHA and many private lenders, if there's a deficit per unit of $10,000 or more, again, they don't want a loan on a property like that because, again, when you get that far behind, you're probably looking at a large special assessment. So that's an important number to look at from the overall perspective of the HOA and the membership within it. And then lastly, at the bottom, again, just an order of magnitude, this association is currently 35% funded, which is a little low. I think you would all agree that if your financial advisor told you that you only have 35% of the money that you should have in your retirement account, you would worry about your retirement at that point. So in this scenario here, they say, well, we want to increase that by that $39. And if you follow our recommendation, well, at the end of the year, you'll increase it to 38.58. And of course, as time goes on, you'll continue to improve that number. And then they have to adopt a funding plan. It gets very detailed on how much of the reserve contribution, any special assessments, interest income that you have, net taxes. It anticipates the component costs. So it lists your net disbursements each year. Some years you bring in more than you spend. Other years you spend more than you bring in. Taking into account your beginning balance will show you with all of that calculated, what your end balance is, what your accumulated depreciation is versus that cash balance, and whether you're over or underfunded. And in this case, as we spoke about just a moment, you're $6,000 per unit underwater. But if you follow the recommendation of this reserve analyst and you increase your contribution rate, you see over time, it goes down from the red and it picks up and it ends in 2052 at a positive amount to make that you're fully funded. So each association, each reserve study is going to have a funding plan. An association is required to adopt a funding plan and provide that to its membership in that annual disclosure statement that we talked about previously. And then wrapping up here, this is the most important. This is the assessment reserve funding disclosure. And this document is in the civil code and it was created by you. That's right. The real estate lobby put this in there because real estate reserve studies are very big. The average one is like 150 pages. It's a lot of information. So they try and cull it down into just a few pieces of information. So, you know, what are the current assessments? How much is going to the reserve contribution to? Are there any special assessments that have been approved? Okay, if so, list them. Base number 3, okay, based on our current policies, right, our adopted funding plan, are we going to have enough money over time? And you see it's in that green, sufficient. Yes, that's good news. If it's not, it will be red and say insufficient. So that's important numbers to work out. And then 6 and 7 just show you different methodologies on how they fund and where the association is at time. So the good news, if you have this particular document, then you have what we call insurance from getting sued because you have given this information to your prospective purchaser. So after they move in, if they find out that they're well-funded or poorly funded, well, guess what? They knew that, so they can't go back to anybody, whether it's you, the real estate broker, or the HOA, and say, hey, I didn't know, because guess what? You were told exactly about that. Now, if there is no reserve study, then they don't get this. However, again, CAR is taking care of you. The standard CAR contract has a little check mark that said, yeah, a reserve study is a good idea, but we don't have one, so I'm going to buy blind, right? This is a 3-bedroom, 2-bath, and a great school district, so boom, I'm just going to buy blind. and then they move in, and then they get the surprise assessment. As I mentioned earlier, they call it a special assessment, but it's often a surprise. And my recommendation to the real estate industry is don't let an HOA do that to you. Don't let them take your referrals away, because that's what happens. At the start, we talked about the good outcomes. Well, again, once they move in and they don't know this information, 2 or 3 years, 6 months, doesn't matter what it is, down the line, they get hit with a special assessment. Well, now that outcome is less desirable for them. And then they say, hey, what did my real estate agent do for me? Well, they didn't provide me with this, so they're less happy. And that, of course, impacts how much they're going to refer you and future business. So, in closing, a few things that we recommend to real estate agents. One, ensure your clients have copies of all the important HOA documents, the CC&Rs, policies, enforcements, budgets, all of that information that we talked about is available through escrow. Ensure your clients understand the use restrictions. So parking, rentals, short-term rentals becoming a big issue, of course. So all of the policies and procedures of that HOA, again, going to be listed in those policies and procedures that you have access to. Ensure your clients understand the financial condition of the HOA, reserve study, budgets. Are they poorly funded? Are they moderately funded? Are they well funded? Those are all going to impact, of course, how much money they're going to pay, but also their risk of special assessment and future increases. And then last but not least, make sure your clients consult with a licensed insurance agent who is experienced in common interest developments so that they understand what type of insurance they're going to need to add on to the HOA policies. Because as Michael mentioned, HOAs are required to have that. But of course, there is risk with each homeowner, regardless of the type of property that they're purchasing. So you want to make sure have an HO6 or an HO3 policy that meets those needs, again, specific to what your HOA is. So with that, I see a few questions that come in. I'm going to do my best to answer them and see. So when was the Laguna Woods hack? I don't know. I understand there was, but they're not a client, so I don't have that specific information. Oh, somebody answered that, 2021. The HOA is a good condition even with this issue. Yes, again, you can look at their reserve study. I do know the person that provides the reserve study to Laguna Woods, and they do have a very comprehensive reserve study, and they update it annually. So yes, you can get that information before purchasing in Laguna Woods. And what happens if no one wants to serve on the board for a small HOA? Well, worst case scenario, you go into receivership. That's a whole nother topic. So you just encourage people to protect their own interest, right? I mean, if you live in that HOA, I understand that serving on a board can be time consuming, but you know, the value of your unit is directly proportionate on how well that association runs. So it may be in your best interest to get you and some of your neighbors to serve on that board. And then the last one, explain why some of HOAs don't accept HOA fines flows. Well, some associations don't see the benefit of being what they call FHA approved. I don't agree with that particular philosophy. There's a lot of people say, well, because FHA has more lenient requirements, right? They have a lower credit score, lower down payments, et cetera. They think that, oh, well, undesirable people are going to move into our neighborhood. I don't buy into that theory. So some associations do not get on the FHA approved list, meaning that they can get FHA financing in their community, and will go on what we call the blacklist. So the list of communities that can't get FHA financing. And the problem with that, as I mentioned earlier, they're not going to get the best financing. So when you go outside FHA, you're going to have higher down payments, you're going to have higher interest rates. So of course, you're not going to be able to pay as much for that home. So the value of those units in the non-approved FHA communities aren't going to be able to sell the same as surrounding communities with similar amenities that do have FHA. So you actually improve the value of your home by being in a community that does allow for FHA financing. That also demonstrates that you are fiscally prudent and sound, therefore reducing your risk for special assessment or large increases to the ongoing assessments. So with that, I will stay here for a couple more minutes, but we are exactly at 1 o'clock. So with that, we have completed the program. Thank you all for your participation and your good questions. We appreciate that. This program, as was mentioned earlier, will be put on the CAR website. And by the way, it is not on a paywall. So if you have friends or relatives or potential clients that you want to expose to this great information within a few days, certainly in a week or so, this will be on the website and they can watch it themselves. So I hope you will take advantage to see it. By the way, we'll be back next year. As we mentioned, this stuff changes every year. So we come back and we educate you every year. We do it 2 or 3 times a year, and we've been doing it since 2019 and have enjoyed every moment of it. So we appreciate your participation. David's info. His name is David Wonkel, and he's with Iger, Wonkel, and Bonkowski. And if you go to caioc.org, you can find all of the contact information for David. Same thing with Michael and myself, or anybody else that is a member of the chapter. They have a membership directory. So if you're looking for management companies or service providers, you can find them on the website. And again, it's in the chat box there, but I encourage you to download both the PowerPoint presentation and the Davis Starting Act, because you will find yourself wanting to refer to that at some point in time. So I encourage you to get that and keep it handy on your computer. Now, thank you for the kind words. We appreciate it, and we thank you for your participation.